Welcome to the Three Questions webcast series. I'm Wayne Baxter with One Capital Management. At One Capital Management, we develop and implement strategies for our clients which strive to grow, protect, and ultimately distribute their wealth. And we do that by offering investment wealth management services. Thank you for taking time to check us out. My clients are often referred to as cross-border clients. Now, why is that? Well, it's because they're either U.S. or Canadian residents who wish to invest in U.S. and or Canadian dollar denominated securities like stocks, bonds, and ETFs. Our process for advising our clients includes an in-depth discovery and diagnostic analysis of their wealth management goals and objectives. And as one would imagine, in some cases, a discussion about an upcoming divorce could be a part of that discussion. According to Statistics Canada, the proportion of Canadians married couple between 2000 and 2020 who would divorce before their 30th wedding anniversary was about 25.5%. This rate doesn't, of course, consider mortality or migration. According to statistics here in the United States at divorce.com, the United States has the sixth largest divorce rate in the world, with 40% to 50% of married couples filing for divorce. Second or third marriages in the United States have an even higher divorce rate, 60% for second marriages and about 73% for third marriages and in divorce. Baby boomers have the highest divorce rate among other generations at 34.9%. So on this episode of the webcast, we're going to speak to a family law attorney to discuss the divorce process. On this edition of the webcast, we're going to be asking the three questions you should ask before filing a divorce. Joining me is family law attorney Christina Djordjevich, founder of the Los Angeles, California law firm Djordjevich Law and Mediation. Christina received her law degree from Columbia Law School. Christina is also a graduate of the National Family Law Trial Institute in Houston, Texas. She received her mediation training at the Center of Understanding in Conflict. Christina frequently lectures on family law topics, and she's licensed to practice law in California and New York. Hello, Christina. Great to see you. Thank you for joining the Three Questions webcast today. Really appreciate having you here today.
Thanks for having me, Wayne. I'm excited to be here.
You know, we got a lot to go over today. At the open of the webcast, I mentioned that anywhere between 40 and 73% of marriages in the United States will end in divorce. Now, I suspect that most of your work is divorce related, but I got to ask, are you finding more couples coming to you looking to establish prenuptial agreements, understanding that the odds of a divorce are so high? Is that something you're seeing more of?
Yes, definitely. And I regularly draft and negotiate premarital agreements. I would say the two groups of people that, have always sort of come in for premarital agreements are those who have a lot of premarital, like pre-existing wealth. So that could be something that they've built up or, perhaps
Or an inheritance they may have received.
Exactly, family or intergenerational wealth. Another sort of category are folks who are on a second or third marriage, perhaps, who want to both provide for their new spouse, but also provide for their maybe children from a prior marriage. But what I'm seeing a lot more of are young couples who potentially there's no higher earner, both are working, and they're looking for a premarital agreement because they just want the certainty that comes along with entering into an agreement like that. So they'll know what will happen in the event of a divorce or death. Those are a little trickier because when you have a young couple, so much can change going forward. I mean, they may, when they come to me, my client may say, hey, I'm certain I'm, always going to be working. But, you don't know if a spouse, if they have children, if a spouse may change his or her mind, want to stay home with the children. And then there may be that sort of imbalance of, earning capacity and all that. So, I always want to explore all the different alternatives. I mean, or also disability that can happen as well. So, want to be really careful with property rights and spousal support with young couples as well. But yeah, definitely I see a lot of it.
I was just thinking as you were sharing there that I could imagine there'd be some circumstances for couples that have been married, maybe they're on their second or third marriage, where they would actually have to have some provisions put in place because of their terms of their previous marriage. In other words, they may have obligations, financial obligations that need to be documented in an agreement with number two or number three.
Absolutely. And that's actually something that goes into those agreements as a recital, that everybody's on the same page going into the marriage. These are my minor children from the prior marriage. This is my spousal support obligations.
Exactly. Exactly.
Yeah. I mean, another actually way that that comes up is that a lot of agreements will have provisions that say, hey, if I have a spousal support obligation from a prior marriage, for example, that I will satisfy that from my separate property, not from, community or marital property. Or if I do, there'll be a reimbursement, but we can talk about all that.
Yeah, I know and actually, speaking of common law, as you know, I'm originally from Canada, and in Canada, you're considered marriage if you're living common law, right? In other words, if you've been living together for a year, even if you're not married, you are basically, if you're living in a conjugal relationship, that's a person who's not your married spouse for 12 continuous months, you're considered to be married. And in those instances, up in Canada, what they use is something called a cohabitation agreement. And that agreement can spell out what will happen to the couple's finances if they separate. So I got to ask, I don't think I've ever asked you this before, but is there a similar agreement here in the United States in those instances where people are just living together, but they're not, they never tied the proverbial knot?
So to answer, question one, in terms of common law marriage, very few states in the US have common law marriage. I was looking this up because I think it's like, I want to say it's less than 10. That very few states have common law marriage. However, in California, for example, we don't have common law marriage, but we do have cohabitation agreements, because there are these things in California called Marvin claims, which come from a 1976 California Supreme Court case involving a very famous actor. And basically what that case says, and what we see in California, is that couples who are not married, but they're, partners in a relationship, they can bring a claim potentially based on what they say is, oh, there was an agreement, whether it's written or
verbal.
Exactly. Or a verbal, or, just a claim based on an alleged agreement to either share property or support the other one. So I often advise, if I have a client who's living, with somebody or in sort of a, relationship like that, I'll always say it's a good idea to have a cohabitation agreement in place. And, what those say is, okay, they're memorializing what the relationship is, essentially saying, we are not creating joint property, unless we go through these mechanisms, put joint names on it or whatever it is. There are no promises to support other than, I'm paying the living expenses for the house we both live in, as an example. You can have any provisions, or, if we break up, this will happen financially. And there's also a release in those agreements frequently where they say, okay, the parties will say, okay, that this agreement controls any potential claims either person could have had are, being waived. So yes, we do have cohabitation agreements here, though that's not, I used to practice in New York. Really, people were not doing cohabitation agreements there. So you'll, if you live in the US, you'll definitely want to check your state and talk to an attorney there.
Exactly.
Situation. Yeah.
And just going back to this idea of the cohabitation agreement, one of the issues in Canada where common law relationships was, once the relationship, or if the relationship were dissolved, sometimes one of the couples will claim a right to property that the other partner were to inherit, right? So these are just some of the risks, and the family may not want that, right? It could be, so that's where you want to get these things down in writing and get everything understood in advance.
Definitely.
You're gonna have a big hornet's nest there. Okay, we got a lot to unpack here. Let's get to our 3 questions, and these are the 3 questions you should ask before filing a divorce. And obviously, we talk about wealth management here on the 3 Questions webcast quite often, so that will lead me to the obvious first question, which is, what are the financial implications that arise from a divorce?
Okay, great question, and of course, a question that I get asked all the time.
I bet you do.
What's going to happen, right? What do I stand to lose? What do I stand to gain, depending on who you're representing? So, the first thing is property division, and this is sort of universal, and I'm sure it is in Canada too, but every state provides for some kind of property division. And that can be debt division as well. So assets and debts. Most states in the US have a model that is referred to as equitable distribution of marital property, which means the court is not bound. They usually often do divide the marital property 50-50, but they are not required to. They, in equitable distribution states, for example, New York, a court can fashion an unequal division. For example, they can look at if a spouse doesn't have much earning capacity going forward, what contributions the spouse made, things like that. In community property states, which California is one, I believe there are 9 in the US, any marital property called community property is divided equally at the time of a divorce. Now, it doesn't mean, of course, that each item is necessarily getting split down the middle. It could be that, one party gets this account, one party that gets this account, but there's an offset. One party may buy another out of a house, but at the end of the day, the division, unless the parties agree to something different, the division of the assets and debts needs to be equal. So this is pretty straightforward when it comes to things like accounts. I mean, there are tax implications, obviously, that need to be taken into account.
Yeah, if you have a trust account versus a 401k, they're taxed entirely differently. So that would have to be
right. It's got to be apples to apples, right? So in other words, somebody getting cash is different than somebody getting
a retirement account.
Exactly, retirement account or a stock account, for example. Even within a stock account, it's got to be apples to apples. In other words, somebody has maybe taking on stocks that have a certain basis, that are different than other
right.
stocks, even from the same company, for example.
Right.
Sure. A lot of thorny issues can arise also in business valuation. If a spouse has a business or is a partner in a business, that can be obviously a disputed and time-consuming issue to value the business. And, is there cash to buy the other person out? Do both spouses, does the shareholder spouse, if there's not cash to buy somebody out, does the shareholder spouse need to sort of maintain the business and account to the other spouse for their interest in any distributions, things like that, even after the divorce is over for some period of time, until somebody.
I would also think there would be some discussion about existing life insurance policies, for example.
Definitely. Yes, definitely. Whole life policies with value in them. Yeah. Yes. So, basically, I mean, every state that I'm aware of, though, I mean, I'm not practiced, of course, everywhere, but has also the concept of separate property, though, which is typically, in California, that is not divided in a divorce. Separate property is property that you can prove you owned prior to the marriage. I mean, there are nuances with all this, but just the basic overview: property that you inherited is another category, property that you individually received as a gift. Those categories are not divided. But property and debt division is, everybody knows that at the time of a divorce, that's going to get divided.
So especially if you're living in California, you're getting married, and you're going into that marriage with property of some sort, that's example one of why you want to sit together with an attorney and sort of identify what is mine, what is not mine, and make sure that property is kept separate going forward.
Right. And actually, that's a great point. And sometimes premarital agreements actually are simply devoted to that concept. They're called confirmation agreements. Because once you get married, it's actually, even if you own something prior to marriage, if that's throwing off income that you're then using for something else, and people oftentimes, nobody thinks they're going to get divorced. And so, they start mixing money and accounts.
Exactly.
Like that. So it's really prudent, if you have separate property that you want to protect, either to meet with a divorce attorney to say, okay, how do I protect this? Essentially, how do I make sure that this stays separate? And another option, of course, is to have a premarital agreement that says these items everybody acknowledges are separate. They were owned prior to the marriage. And basically go through all the permutations of what happens if there's any mixing or things like that, to spell out there's a reimbursement right, things like that. It's just good to go.
And it just leads me again, as we go down the rabbit hole here ever so quickly. I just thought of an inheritance situation after the marriage, and after the marriage is going along for however number of years, one party inherits a sizable sum of money. They had to think long and hard about what they want to do with that. Well, they want to keep that in a separate, identify it in a separate account. Like if it's liquid asset, they inherit $1 million or whatever. If they keep it separate through the whole time, they will, just like something they bring into the marriage, they'll be able to identify that as separate property, even though they received after the marriage.
That's correct. That's right.
Whereas if they inadvertently or in good faith put it into a joint account name, as soon as they do that, it's now community property.
Well, it's particularly when it's mixed with other funds.
Exactly.
And that's where things get very complicated and expensive, because if you start mixing it with other funds, you deposit that into an account with a sizable balance, or that people are using all the time, depositing new money, and it requires a very costly tracing at the time of a divorce, that can really be very expensive.
I know, actually, I do know, and I should actually have her on as a guest one of these days. I do know a forensic accountant who does exactly that type of work.
Yeah.
You've just given me an idea for an upcoming webcast. I'm serious, because that is a job unto itself. The forensic accountant who basically goes in and looks at the finances of a family looking to get a divorce.
Absolutely. It's an
another topic for the webcast. Thank you.
Yep.
There we go. Okay. So, we all know that the finances are a big part of this, divorce discussion. And I think we were debating about which question to put first here. But again, the next one I think we really have to get to is what's going to happen to our children.
Yeah, but before we get to that, if it's okay, there are just a couple more, just to note a couple.
Not a problem. Go ahead.
And I'll run through them really quickly.
No, go ahead. It's fine.
Good to know. Yeah. So the next sort of financial implication that people need to be aware of is spousal support.
Oh yeah.
Yeah. Spousal support. It may be known in your state, if you're in the U.S., as spousal support, spousal maintenance, or alimony is a term that everybody knows. I don't know what they call it in Canada. Wayne, do you know?
Alimony, spousal support.
Okay. So basically, spousal support is a payment that is made from one spouse to the other after the divorce. I mean, there are really two types of spousal support. There's temporary spousal support, which is paid during a divorce while the case is pending to keep everything, sort of status quo. So everybody, so that the out spouse, which is what we call the non-breadwinner spouse, can continue to pay their expenses and live. Mm-hmm. At the time of a divorce, then the permanent or post-judgment spousal support starts. Typically, it's a payment that goes on kind of depends on the length of the marriage. In California, if you are married for longer than 10 years, your spousal support obligation is non-durational. So the court typically does not set an end date at the time of the divorce. Doesn't mean you're going to be paying forever, but it means you got to come back to court later down the road to argue about the circumstances. If you're,
for example, if the so-called out spouse were to get remarried, correct. Even if you, in other words, if you were married first time around for over 10 years, you're basically potentially could be required to support that spouse for an indeterminate amount of time. However, if that individual got remarried, you could then go back to a judge and say, wait a minute, Exactly.
Remarriage, if the supported spouse gets a job, perhaps the obligation would need to be adjusted. If the supporting spouse retires, reaches a certain age, 65, and wants to retire, that's another circumstance. So it's very fact specific. So I mean, and every state has different laws, of course, about spousal support, but the concept of alimony and spousal support is pretty widespread. In the U.S., spousal support now federally, from a tax perspective, is no longer deductible for the payor. It was for a long time. It is no longer deductible, but actually in California, it is deductible under California law for your state tax return.
For the state tax, but not federal.
Correct. Yeah. So spousal support, in my experience, clients are pretty much, when people, are ready to get divorced, they know, all right, I'm going to be parting with half my assets roughly. They know that there's a property division. I think spousal support is often for the supporting spouse sort of the harder pill to swallow a lot of times. But I mean, from a policy perspective, it does make sense. One spouse, maybe, there's an agreement between the spouses where one spouse didn't work, raised the children, dependent on the other spouse, whatever the circumstances are, that spouse can't just sort of be, left high and dry. That's the policy. The next, and I'll move through these. The next financial.
No, it's okay. You're good.
Okay. The next financial implication is child support. If you have minor children, child support is required. And that is a formula-based calculation. When you get into really, really, really high earners, it changes, not always strictly formula. That's for another webcast, just that topic. But generally speaking, it's formula driven and dependent on, number of, kids and things like that. So in California, it goes till the child's 18. In New York, it's 21. So check your state if child support is if you have minor children and you're going to be getting divorced. Another one is life insurance, something we spoke about. And oftentimes, so the court does have the discretion to order a life insurance policy to secure a child support obligation or a spousal support obligation. With respect to child support, for example, it can be put on a declining schedule. In other words, the child is going to, the support stops at 18. So you secure enough to go through and each year, usually orders will provide, the judgment will provide that it can be reduced each year. Health insurance is another thing to consider, because now, typically everybody's been covered on the same plan. So, the one spouse will need to get his or her own health insurance policy. And lastly, which I will touch on later, is the issue of attorney's fees. Of course, a huge financial consideration, one to know, and that often will guide, that consideration will sometimes guide what divorce process you want to use, which we will talk about later in this webcast.
You covered a lot there. So a lot of financial obligations, and again, I talk about planning. Nobody ever plans to have a divorce, but I think the point that you make is that there needs to be an initial consultation, and this needs to be thought through before you jump into the deep end of the pool and decide how you're going to proceed. So that initial consultation is infinitely important before you make any kind of declarations. No questions there at all. So now let's go back. I mentioned it earlier, but now that we've gone through all of the financial implications, you get into, you mentioned child support, but there's also the question of what's going to happen to my children. Now I go and tell my spouse I want a divorce, and I got, 1, 2, 3, 4 children or more to be considered with. So how do you integrate children into this discussion?
Yeah, so there are two. So, child custody it applies to children who are under the age of 18, so minor children. And there are two main components to child custody. That's legal custody and physical custody. So legal custody is because now your family is entering into a new normal, right? I know that expression was overused.
A new dynamic, yeah, for sure.
New dynamic, yeah, exactly. A new stage, right? So, the way that decisions were historically made may not be the way that they're made going forward. So legal custody is how decisions will be made for the children in major decision-making areas. Usually we think of those as like healthcare, medical, things like that, mental health care. That's all kind of under healthcare. Education is another big one. And there can be joint legal custody or sole legal custody. Joint legal custody is what it sounds like. The parties make decisions together. There needs to be mutual agreement in those major areas. Generally, each parent can make day-to-day decisions, that aren't, in sort of one of the major areas on their own, if they're fit parents and fit decision makers. But joint legal custody means for certain high-level decisions, there needs to be an agreement between the parents after consultation. For some couples, that's no problem. That's how they've operated before. That's how they'll continue operating going forward. Sometimes there can be, I'll just contrast the joint legal custody with sole legal custody. Sole legal custody is, of course, one parent being in charge of making decisions. Now, you can even split up realms of decision making. So, for example, let's say, the parents have always been pretty much in agreement. Everybody's pretty competent in terms of making decisions. So they're going to have joint legal custody on educational matters, for example. But let's say one parent maybe is a doctor, or maybe, and the parents haven't gotten along, and so decisions are delayed. Maybe that parent may have sole legal decision making for medical issues. As an example, it can be sort of carved up, and really there is no one size fits all custody agreement. I mean, there are kind of parameters, general parameters, but it can be finessed. The other, I mean, and really in California, we see a lot of joint legal custody, assuming that parents are competent and fit and able to make decisions. Physical custody is the other aspect of custody, and that is where the children will be going back and forth, who they live with, timeshare, those type of concepts. So again, there is sole physical custody and joint physical custody. So joint physical custody can be a variety of different arrangements. And that's, again, in California, that's what we really see frequently is joint physical custody, provided, of course, as always, that, both parents are fit, competent, able to, act in the best interest of the child, which is always what the court is really focused on, best interest of the child. So, as the children get older, it may be an equal or a roughly equal schedule, depending on the ages of the children.
It also related to whether one spouse is working or not, and you've got those other factors as well, right?
Yeah. Although, yes, definitely. I mean, a parent is allowed to, at least in California, to use childcare during their time. In other words, doesn't automatically revert to the other parent simply because a parent has to have childcare while they're working. But, the sort of traditional schedule when there was a working parent before, you'd often see, okay, the parent who was working a lot may have, alternating weekends and a midweek overnight. That was kind of the typical schedule, but we're really not, the courts have kind of moved away from that. As long as parents want time, can use the time, are good parents, it'll often be roughly equal. But of course, older children, I mean, the schedules can be week on, week off. It can be a couple days a week, couple weekdays with one parent, couple weekdays with the other parent, alternating weekends. There are tons of different ways to do it. And even when a parent has sole physical custody, which is more rare, but of course, when there are concerns, when there are issues, of course, that's something the court can do. But that doesn't mean sole physical custody doesn't mean that the children never see the other parent. It just means they primarily live with one parent and they have visits.
I got a scenario for you. I actually had this happen with clients of mine back in Canada.
Okay.
And I remember when the news broke that they were getting divorced. I was like, it was one of those couples that I was just dumbfounded. Could not believe it. They seemed like the happiest couple under the sun, right? And they wanted to create as less havoc as possible for their children. So you know what they did? They kept the main house and they got an apartment. And the parents, instead of the kids moving anywhere, the kids stayed exactly where they lived in the main house. And the parents alternated between the apartment and the principal residence. And they did that until I believe it was the wife remarried. And they also ended up both of them remarried. But I remember for a period of time, not just weeks here, I'm talking an extended period of time, they basically rented an apartment and they would literally go 1 week, one person would stay in the apartment and the other week, the other spouse, and they would just back and forth.
So that arrangement is called nesting. Actually, nesting because, birds nest, the children stay in the nest and the parents rotate in and out. It does not work for all families, but I think it can be great for the families it does work for. The fact that they were sharing an apartment,
I know,
but the fact they had an apartment that they would alternate. That's more rare. What I've usually seen, and so often nesting requires resources because oftentimes it will be the main house and then each parent has a separate residence in addition to the house. So
Yeah.
that's, because a lot of times couples who are getting divorced don't want to,
They want to share the same place
yeah, or even like
for lots of
alternate.
reasons.
Yeah, exactly. Exactly. They want to
That
just,
was a good one. That's a for sure thing that happened. I remember it like, I don't know. It was a totally shocking situation. And
yeah,
anyway, it all ended up resolved. They both remarried. They're both happy. Everybody was compatible. There was, from what I said, very little acrimony during the whole situation. But it was,
that's great. I mean, honestly, like, look, some cases, and we'll talk about the different processes. Some cases require litigation, in some cases
yeah,
there just is necessarily acrimony. But in a case where if it can be avoided, that's generally best.
yeah, which perfectly segues unintentionally, but sort of intentionally, into our third question. So we've dealt with the finances. We've dealt with how to handle the children. But ultimately, the question that's going to come down to, I would imagine they're sitting in your office talking to you, is like, what kind of approach is the best one for me, given my situation?
Yeah, yeah,
That's really
definitely.
the question. Like, what do I do?
Yeah, definitely. So there are three key approaches. Well, we can also call them processes, approaches as to how to resolve a divorce. And each of these three approaches involved professionals. So I'm assuming in discussing this that professionals are going to be involved. Of course, if parties are able to do basically like a kitchen table deal, they can sit down and communicate with each other and they work out a deal. They just want a lawyer to write it up. That's a process. It is. But for purposes of today, there are three processes we'll go through. So the first is we'll call it traditional litigation model. That is where each party typically has their own attorney, and those attorneys will communicate on behalf of the parties. They will, make formal requests for documents, any communication. For the most part, most communication goes to the lawyers. There are often motions filed, so in other words, requests made to the court for certain things. There's a judge, right? The case is usually proceeding at all times on sort of a dual track, right? So the parties are, trying to settle between the lawyers, but at the same time, if the case does not settle, at the same time, the lawyers are preparing for trial. Now, the vast majority of family law cases are settled out of court, don't go to trial. A lot of them will have hearings throughout the process if there are disputed issues about things, which there often are. But in terms of an ultimate trial, it's rare. And also, just because parties proceed or start out with a sort of traditional representation model where each side gets a lawyer, it doesn't necessarily mean that there's going to be a full-on war. I mean, once the initial, there are certain financial disclosures that are required in every state that each party exchange. Once that's done, and oftentimes attorneys will cooperate and parties will cooperate with providing necessary documents and things like that. There's no reason the case can't settle quickly as long as the parties want to, with each side having their own lawyer. But that's sort of option one. Option two is mediation. Mediation is gained a lot more popularity. I'm seeing it a lot more, where parties will meet with a neutral mediator who will facilitate their dialogue and their exchange of information and will attempt to assist them in coming up with an agreement. Oftentimes, I think it's good, usually for that mediator, I think it's helpful for them to be a family law attorney. And oftentimes one or both parties in a mediation will have their own consulting attorney on the side. So they can, talk to that consulting attorney, talk to them about the deal, see what information they need to get. But it definitely, a mediation sets the tone, and it's for folks who want to try to
Or
resolve.
conciliatory, that they want to make this. But what you're saying here, though, with the mediator, is that you will likely still have your own attorney, even if there's a mediator involved, is what you're suggesting.
It depends on the case. It depends on the case. If it's sometimes not. I think it's usually a good idea, particularly if there's sort of an imbalance of knowledge as to finances and things like that. I think it can be I think it is a good idea, even if it's just, having a consulting attorney review the judgment that's prepared. I think it's a good idea to have that consulting attorney, but the difference is that a consulting attorney, I mean, they get involved sometimes. Sometimes they're more involved. Sometimes they're more in the background. But generally, and a lot of times in the mediation room, it's just the mediator and the two parties. The consulting attorneys are spoken to, sort of separately. Not always, but most of the time. And then, whereas with litigation or with the traditional representation model, it's always pretty much the attorneys are going. I mean, not like the parties can't talk to each other, but it's the attorneys that are doing most of the negotiating, discussion. Mediation, not for everyone, not for every case. Obviously, if there's domestic violence or things like that involved, mediation, not a good option. If there's, I mean, that
with a difficult situation, I think we're back to number one.
Yeah. And at any time, parties can choose.
And that's where, by the way, that's where we're more likely to have the diagnostic analysis of the financing done by the expert CPA to come in and do a breakdown of all the finances.
Yeah, although
usually on number one.
Pretty much very often in number one. Yeah, mediation though, a lot of times parties will have there will be either a neutral accountant involved, or each party will have their own accountant.
But you're not getting a forensic accountant involved most likely when you're mediating. I'm guessing you would know better than me.
It depends. Yeah, it depends. But a lot of times, I think people are attracted to mediation because it can be a lot cheaper. It can be a lot more cost effective than having sort of two attorneys, every communication going between them, things like that. But I mean, in mediation, there can definitely be multiple. But you're right. Yeah, in a situation where somebody might be hiding something, hiding assets, that is generally like not going to work in a mediation.
No kidding.
Mediation requires everybody to be, because it's voluntary. It's a voluntary process.
Right.
So everybody needs
There's a level of good faith involved.
Exactly. Got to be good faith, got to be forthcoming with the information. And if somebody's not doing that, it's time to terminate that session.
So we have traditional with two attorneys. You got mediation. You said there was a third. There's a third approach.
Yeah, the third is called a collaborative process, and so that is something that is a fairly new-ish process. So collaborative law process is very unique, and the sort of so each side still has their own attorney in a collaborative process, but the hallmark of a collaborative process is that each attorney at the outset signs an agreement that says, if the collaborative process, which I'll explain more, if it falls apart, if it doesn't work out, if the parties want to move to a more traditional road, that neither lawyer can represent the client in court.
Oh, really?
So it's essentially it is a commitment by the lawyers at the outset, it is a commitment sort of by everyone at the outset, but the lawyers to attempt to resolve this and to sort of approach the matter in a collaborative, respectful, amicable way. So that, because they know if it falls apart, that's not their client anymore. The collaborative process also involves a team. So it's not just, both sides have a lawyer. There is often also a financial professional involved, either helping each side or a neutral. And there are coaches involved, mental health professionals, either one coach that's sort of a neutral, or two coaches. Each party, they're not called parties actually in collaborative, they're each client or having their own coach to address challenging dynamics that may come up during the process. It's a team approach it's about assessing all the having a team in place to assist with dynamics, to process the information, to present options, to really help the people come up with an agreement that's right for their family. I think the collaborative process, it does require some resources because, you know, I mean, you can have, depending, you know, you don't have to have every team member all the time, but it does require resources.
You're involving a lot more people, and these people need to be compensated for their time. So, I mean, it's
Exactly.
pretty obvious that it's going to be a little bit more involved
Yeah, it
than
is.
if you suppose you just have two attorneys negotiating.
Yeah, I mean, in terms of the cost, I still think it can actually be probably less. I mean, it can definitely be less expensive than the traditional model, only because, you know, the traditional model also involves experts, you know, preparing for trial. You know,
The forensic attorney, the forensic accountant. I mean, the forensic.
Exactly.
Yeah, that's going to be
So
that would be interesting. My word.
So I was just going to say on to close out the approaches and the processes. I think it's a good idea to talk to, you know, if you're thinking about a divorce, I think it's a great idea to meet with a divorce attorney to figure out in your specific situation, you know,
100%.
which of these processes, which of these approaches is right for you. And, you know, yeah, because each one of them kind of can set the tone for the divorce. And it also impacts, you know, attorney's fees, of course, as we've talked about.
Yeah, well, so I do have, I know it's we'll call it the follow-up question here before we wrap up. And, you know, to me, it's like, okay, we've talked about the finances. We've talked about how we're going to take care of their children. We've talked about multiple choices, you know, traditional, mediation, collaborative. And I guess I know it's not our third, it's our, we'll say 3.1 question is, how long is this going to take? I mean, that's got to be at some point, somebody's going to have to throw that one at you.
I get asked that
I bet you do.
all the time. And I'm going to give a classic lawyer's answer.
I know the answer already.
Can you guess it?
Yeah. It depends.
Yeah. and it really, really, really does. I mean, and it depends. I mean, but how to basically, I mean, you know, if they're relatively, I mean, it depends on complexity of the case, right? That's one major factor. Are there businesses to value? Are there tracings to be done? You know, are there other complex assets that need to be analyzed? Or are we talking about a house, some bank accounts? You know, I mean, so
I would also think it would depend on what state you're filing your divorce in.
Yeah, of course. Yeah.
Right.
Definitely.
Some states are more, take longer than others, I would suspect.
That's true. I mean, courts generally are backed up. I mean, if your case is going to a trial, like the process is going to take years. I can confidently say it will take years. You know, by the time you start everything, get everything going, do whatever you need to do during the case, and then, you know, set a trial date, years. You know, but you know, complexity of the case, you know, level of contestedness, I guess, like level of you know,
acrimony,
exactly. Level of acrimony in the case. And also I mean, transparency in the case. I mean, because, you know, in California and in all states, there is a duty to disclose your financial information. And so the longer it takes someone to provide that information, the longer the process drags out. So it totally depends. It also depends on these, you know, which process you select. You know, I mean, I think people are drawn. Sometimes they want to mediate because they think it'll be faster, you know, or sometimes they want to go, okay, traditional model, but let's, like, you know, really let me hear all my documents, like give them whatever they want, receive what we need to receive, and at that point, I mean, you can make a settlement proposal. You know, I mean, if it's right, if it's appropriate to do that. So it depends.
As always, it depends.
Yes.
You know what? Christina, you've been an awesome guest. I swear, you've been tremendous. You've covered so much today. You know, we're here to provide clarity and guidance, educate and inform. And, you know, you checked off all the boxes perfectly. I can't thank you enough for joining us. And, you know, sadly, I have to say, you know, there are going to be folks watching today or listening today that are going to be, they're going to, you know, their marriage may not be going the way they want it to, and they're going to need advice, right? So I guess the thing I got to ask is this: is for anyone who listened to or watched today, what is the best way for them to reach out to you? How should they contact you? They do it by phone, by email? Like, what is the
I would say,
what's the best way for them to do that?
yeah, so my firm is Djordjevich Law and Mediation. You can check out my website at cdjfamilylaw.com, and you can reach me by email at christina@cdjfamilylaw.com. I would say email, and my phone number is on the website as well.
Yeah, and we're going to include that too. We're going to have your phone number, you have your contact information on your screen as well. But by either website, email, or phone, they can reach you.
Great. Thank you.
Okay, Christina, again, thanks a lot for joining us. Great to have you. Christina Djordjevich is a family law attorney and founder of the Los Angeles, California-based firm Djordjevich Law and Mediation. And she was just a tremendous guest today. Thanks
for having me.
I look forward to bringing you the 3 Questions webcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our YouTube channel. And to receive a notification of when our latest webcast has been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meetwithwayne. Thank you, and see you soon.